Good, good morning. Actually, uh, right to preemption. What was that right? That right originally, it's a common law process. Problem was the when uh, brothers, sisters, and relatives were sharing the property and enjoying the property jointly. Suppose there may be some family arrangement by earmarking their respective shares. They are not supposed to sell that property to third party to disturb the peace of the other members of the family, left out family members. That is called right of preemption. So that subject is a very vast subject, and particularly personal law plays a pivotal role in this right law preemption. In Hindu law, the Hindu Succession Act contains such provisions, and Muslim personal laws also prohibits mahla being sold to third parties uh, with intent to prevent the disturbances by the newcomers and affecting their religious rights. Here, a fantastic case, because this is a case of West Bengal. Mm, the there was a West Bengal Land Reforms Act, 1950s Act. There they have right of preemptions. They say you can, if any property is sold to third parties, you can file an application under Section 8. And after filing Section 8, there will be an inquiry under Section 9. Here in the given case, the mandatory duty of the applicant to set aside, he must deposit entire sale deed and also 10% of additional sale deed in order to set aside that sale. You kindly see, this is AR 2020 Supreme Court 2175, Abdul Matin Malik versus Subrata Bhattacharjee. Here several things has been upheld, discussed. Particularly, they say before any application for preemption is considered and further inquiry is conducted as required under Section 9 of the Act, deposit of entire sale consideration with 10% of the sale consideration is condition precedent. Since that was violated, the case was lost. They have discussed about right of preemption is not a right to a thing sold, but a right to offer of a thing about to be sold. This right is called the primary or inherent right. Preemptor has secondary right or a remedial right to follow the thing sold. It is right of substitution but not of repurchase. The preemptor takes the entire bargain and steps into shoes of the original vendee. This is what they say. A very weak right. Right of preemption is a very weak right. Then therefore these aspects you have to go through the entirety of judgment so that you can understand. And so for abundant caution, if anybody wants to file suit for preemption, you also file an application under Section, I think, 89 Transfer of Property Act or some provisions which is available under mortgage chapter to permit the court, plaintiff to deposit the entire consideration. And here in the given act, 10% additional. I do not know what act prevails in Tamil Nadu so far right of preemptions are concerned. If any senior advocate, experienced advocate come across such cases, he may kindly enlighten us. Best wishes.